from a man who assaulted a pregnant woman and repeatedly failed to meet probation requirements
for the offense of assault of a pregnant person. How do you plead to that? True or not true?
Yes, ma'am. True. Yes, ma'am.
to another who faced serious theft charges.
Are you charged with theft of property as a second-degree felony? Range of punishment is anywhere.
These cases show how Judge Boyd handles offenders. Starting with Mr. Salazar, who was given a chance on probation after assaulting a pregnant woman but repeatedly ignored court orders, skipped required programs, and made excuses at every turn.
All right, court is calling 2022 CR 3264 State versus Matthew Salazar. Excuse me, guys, we're on the record. You need to ask the deputy to move you down there. State versus Matthew Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Robert Porter for Mr. Salazar.
And are you Mr. Salazar? Are you the same Matthew Salazar who was placed on community supervision in 2022 CR 3264 for the offense of assault of a pregnant person on December 8, 2022 for a term of 10 years? Is that you? All right. State?
Yes, Your Honor. State is moving forward on violation of condition number 14G on or about the 14th day of May 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to apply for the documentation of attendance and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, battering, intervention, and prevention program in violation of condition number 14G.
How do you plead to that? True or not true?
Yes, ma'am. True. Yes, ma'am.
All right. State?
Violation of condition number 39 on or about the 19th day of April 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to an evaluation for placement into the drug court in violation of condition number 39.
How do you plead to that? True or not true?
Violation of condition number 42 on or about the 7th day of August 2024 in Bexar County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to a substance abuse evaluation with the Bexar County CSCD's Treatment Alternative to Incarceration Program, TAP, in violation of condition number 42.
How do you plead to that? True or not true?
True.
State will waive all
No.
violations.
No objections.
Did you understand by pleading true to violation of conditions 14G, 39, and 42, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 14G, 39, and 42? Court will find 14G, 39, and 42 true. Oh, did you all fill out an application, a trial court certification?
Well, he's on probation, so what should have been one already filled out.
That's okay.
Apologies, Judge.
Well, you know what? They ran out of paper,
Hmm.
you know, the regular one. So this is what they've given us. All right. Is there a proposed agreement?
There is not, Your Honor. We had a partial agreement to plead true to those conditions, so they are not contested and to waive the other condition. And then I believe we're going open to the court with the recommendation of the state and the defense's argument.
All right. So are there any witnesses?
No, Your Honor.
All right. State, what are you requesting?
Your Honor, just given the seriousness of the offense for which the defendant was placed on probation for, he did receive 10 years, probated for 10 years, so he is subject to the underlying sentence for 10 years. For, I do believe he's been on probation since 2022, and he has not done the Veterans Intervention and Prevention Program. He did have substance abuse problems, and all efforts to try and get him to come to compliance and address those problems have been thwarted by the defense. And so for those reasons, Your Honor, state's position is that he's shown that he doesn't want to be on probation. And
All right. And defense, what are you requesting?
Two things, Judge, if I may address a couple of things. We're going to respectfully request that you continue him. A couple of things about the Battery Intervention Program. And he actually was signed up for that back in April. Went to a couple of classes. He was having trouble communicating with his probation department. I showed emails to the state of Texas about that I wasn't lying about just probation department just stopped communicating with him after a certain date. So he freaked out and said, I'm not gonna do it. He was arrested, and before this court, I was appointed 2 weeks ago. He made bond. Since then, he got out. He has signed up for the Battery Intervention Program, and he's set for his first class on Thursday.
So why hasn't he followed the court's instruction with regards to felony drug court?
Well, I'm gonna get to that. I'll
Okay.
go one at a time.
All right, I like the one at a time.
She did speak, she did say that she could make attempts to. That's like,
So, okay. The drug court also, Judge, he was notified, and this is through a series of emails from the state of Texas that we've shared all this stuff together already.
Sure.
And so we're trying to give it in a nutshell. On 4/22/24, he did not qualify for drug court. Now, since that time, they still asked him to come to the court, I guess, to tell him you don't qualify, what have you. On 4/25, he had called up his probation officer and told them, listen, I've been in the hospital. And they said, well, unless you show us some kind of proof that you're in the hospital, we don't care. As of today, I don't have it printed out, but I did see it, Judge, and there's an officer's court on the time. He was in Methodist Hospital from 4/27 to 4/29, which lacks it was the 25th is the day we're talking about, so that's 2 days. However, on speaking with him and his wife, he was sick on the 25th. They had gone to Mission Trails first. Anyway, so the drug court, he
What
didn't
about the
qualify.
April 19th? Because on April 19th, it says that he failed to submit for an evaluation for placement in drug court.
From my understanding, but that was, it goes back further than that, Judge. I think that the train of emails go back further than that, about the dates of what was happening and dates being moved.
All right, I need to
So-
see that, because otherwise I'm thinking he would need to go to prison, but I want to see the email in regards to April 19th.
Well, there's gonna be a trail of emails,
Yes.
because they start like all the way back in April.
it's the case codes for the.
All right, so if I could see those.
And then the TAP judge, other than the TAP, again, we're taking full responsibility of the TAP because we don't want to do that. But at the end of the day, when it came to the TAP and talking to the probation officer, he was told that they were really backed up and he'd be later on, and he was never notified.
Let me ask you this, and if your client is drug tested today, is he still going to be positive for marijuana?
He should be clean, Judge, and that was going to be my second option, Judge. I know there's been a history of the marijuana. We go back and look at it too, and in fact, when he was back in front of this court, he had just got in or just got out of jail, so he had this, but he's been clean for a month, and that reminds me of something else. He's been going to AA meetings since April of 2024. And I did get a letter from his AA sponsor. Says he does AA every Friday. He's been doing it every Friday for the past since April of 2024. In the alternative, I know the probation had asked for, and we are in agreement, should the court decide not to continue him out on the street, probation is asking for Sabbath.
He's saying it's safety.
Oh, I'm sorry, safety. Yeah.
All right, here's my question. Has he done a TAP evaluation? Because in the motion to revoke, it says no TAP done.
I don't think a TAP has ever been done.
And does anybody have the court summary? Any objections to the court reviewing?
Right.
All right, so this is one of my questions from reviewing the court summary. So it says that he claimed that he was already enrolled in BIP with CPS. So I'm assuming that's not true.
Judge, you'll have to, I don't know that answer.
All right, Jenna, raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Happy, sir.
All right, so in the court summary, it states that you told them that you had enrolled in BIP with CPS. So is that true or no?
Yes, ma'am. I already did the, I was enrolled with the BIP, but I got incarcerated for CPS, but I finished my parenting classes and all that for them.
No, BIP is something completely different from
Better
parenting.
intervention.
Yeah, it says on February 6, 2023, the probationer reports he enrolled in BIP with CPS. On March 10th, 2023, officer inquired about BIP and he started crying, states they are giving him the runaround. On April 12th, 2024, officer inquired about BIP and he stated he sent the packet and has not heard anything. On May 14th, 2024, the probationer called and states he called about the BIP and they told him the price. Officer informed him to register ASAP and he states he will try and get the money soon. Officer received a call on June 11th, 2024 from probation stating if his appointment to report should be rescheduled due to his daughter award ceremony. So the question becomes, did you enroll in BIP through CPS or no?
Yes, ma'am. I did, and then I was enrolled in it.
I don't know about the CPS. I know he had enrolled in this was just
Does anyone want a search warrant for the cell phone?
we're not gonna do that. We're not gonna do that. The things on there, Judge, that I need to,
All right.
if that's not. the
I
standard.
won't swipe right.
No, that's.
Is this an Android or is this?
That-
All right, so I know how to use it to.
There's two different phone numbers that a lot of this paperwork was texted to me on, Judge, that I'll be happy to kind of flip back and forth. to
Okay,
give you.
all right, is there anything else?
Not from the state.
Just, again, a couple of last things, that goes to the allegations, Judge. He does work full-time. He works for Lone Star Mobile Home Installers. He transports mobile homes. He's a father of two. Actually a father of three, but he takes care of two full-time. And so we're respectfully requesting either to continue and let him work these issues, and if he can't do that, then probation's recommendation.
All right, so here's the thing, you're getting tested today. What are the results gonna be? And now's the time to tell me if it's gonna be positive. Now's the time to tell me.
I was in jail for the last about a month and I've been out clean. I didn't mess with anything when I got out of jail, man. I can do anything except smoke cigarettes. And last night I took NyQuil. That's because I've been feeling sick.
See, so here's the thing, we're doing NyQuil, and the last time there was an issue with alcohol.
But I explained to him I'm sick. I did take it because I was sick last night.
Well, here's the thing, you're not supposed to be taking alcohol at all. Those are not my rules, that's the legislature's
Oh,
rules.
I didn't
You
realize.
can't drink alcohol at the house when you're on probation, can't do marijuana in your house, just not allowed.
With Dayquil and NyQuil, like for cough and congestion.
No, so you're not hearing me.
Yes, ma'am.
Let me ask you this. Do you read the label on that? Is there alcohol in that? Yes, there is. Dayquil, is there alcohol? Yes, there is. NyQuil, is there alcohol? Yes, there is. You're not allowed to take anything with alcohol in it.
Sorry, I was not aware of that. I'm sorry. I was just really
You
sick.
should have been aware
thought
because
I
you
had
tested
COVID.
positive for alcohol before.
I thought I had COVID.
NyQuil is not going to help you with your COVID. I mean, I could be, I'm not a medical doctor.
Yes, ma'am.
I play one on TV, but
Yes, ma'am. But I have not changed any drugs or anything.
okay. All right. Anything else from either side?
Not from the state.
Up for defense.
Probation. So you all don't have a TAP evaluation on him. Am I correct in saying that?
Yes, ma'am, that's correct.
All right. Can we get an expedited TAP on him?
Let me send a check out to you.
Thank you. You may be excused.
Just like in Matthew Salazar's case, this one centers on a woman who was given multiple chances to comply with court-ordered programs, but still failed to follow through, violating her probation terms.
I actually finished, but I was let go a week early for my needs, like it was medical release. And I moved on to the sober living and I didn't stay there. I got flagged for not coming in on time and I just didn't stay. When they told me I had to wait 2 hours outside of for the sober living so I can come back in, I didn't stay. I just left. I didn't feel comfortable.
What do you mean you didn't feel comfortable?
Just waiting there outside of the gate. That was one of the things that they do when you're late. When you
I mean,
get
those are
flagged.
called consequences, right?
Yes, ma'am.
Family is here.
Mhm.
Here in the back. She has a place to go if the court can allow her back out again. And we have that set up.
Well, what I can tell you is I don't think a judgment satisfied is appropriate in this case. I don't think 2 years is appropriate in this case. You have done some things, but I'm not going to give you a judgment satisfied. All right. So is there anything else from either side?
191 days, Judge, would be fine.
Okay.
No.
Yes, State.
Your Honor, Bayshore was ordered to SATF on November 1st, 2021, but she failed to surrender at the Bear County Jail placement on December 9th, 2021. You allowed her to attend intensive outpatient treatment, but she failed to attend in August 2nd, 2022. There was a compliance hearing because of that, Your Honor. At the compliance hearing on October 25th, 2022, the defendant was ordered to complete a TAP evaluation, which recommended DDOP, but it did begin. That was in February 24, 2023, but was discharged 3 months later on May 23rd, 2023. Probation has already been extended and amended for 6 months to include ERF. Entered ERF November 8, 2023, but was discharged March 4, 2024 with recommendation for safety. And where you are, Your Honor, after all this time, and you can't really help her with her probation anymore. That's why state's making a recommendation that it
Judge, just a reminder, she has never been arrested before this case. This is the first one in. You gave her deferred. She did not do well, and we're not trying to hold her up as somebody who was perfect on her probation. But the amount of time that she's been in is certainly commensurate with what we've seen in this court on some other cases. And I don't think that it's inappropriate to consider something in that 180 to 190 day range, especially with no prior history.
Well, what I can tell everybody is I treat people as human beings, so everybody's case is different. What I may have given, person A, I don't give the person B because I'm treating people as individuals. All right, counsel, did you go over the trial court certification with her?
Let me have her sign it. All this means is that there's no plea bargain and you can appeal if you choose to.
Thank you. All right, and reviewing the file, I did see that in October, your conditions were altered and amended, and you were admonished not to miss any more appointments. And that was me trying to get your attention, and it did not work. So as previously stated, the court is finding violation of condition number 5 true. The court is going to grant the motion, find you guilty. Court is going to sentence you to 18 months in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes,
And did you sign it?
yes.
Counsel, I need the copy because
Oh.
you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Yeah. Can you just make a copy of this? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And I will also request the therapeutic community. It doesn't increase the time that you're in custody, but they may be able to help you in regards to your rehabilitation. All right, good luck to you.
This time we have Mr. Fenton, already facing charges for stealing a car, now trying to convince the judge he deserves probation. Instead of taking full responsibility, he downplayed his actions.
All right, court is calling 2024 CR 010751, State versus Miles Fenton. Can I have parties announced for the record for the state? Defense?
Brent Hardy.
And are you Mr. Fenton?
Yes, ma'am.
All right, you entered a plea to count 1 of no contest. Punishment was to be assessed at a cap of 18 months in the state jail facility. The state is silent on your application. Defense, you waived PSI. Do you have any witnesses?
No, Your Honor.
All right, the court will hear your argument, counsel.
Judge, Mr. Fenton would like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Oh, I'm sorry.
All right, there's something you wish to say?
Mr. Fenton, would you explain to the judge why you think she should grant you probation?
All right, so let's start here. Let's assume you don't have any family. Let's assume you're alone in the world. Why should I grant your application?
Because I intend to be a father. I intend to do what our Father has intended for us to do on this earth. Have a family, be a family man, provide something of this world that we live in.
I'll say, so let me ask you this. If you did not have a family to support, then why should I grant your application? Let's assume you don't have a family to support.
To be honest with you, Judge, boy, I've been playing basketball my whole life, and that's how I plan to take care of my mother, grandparents, all of my family. I got injured a few years ago, and this whole time I've been locked up, I had a chance to get my body in shape, and it's a critical point in my life, my career, that if it's not now, then it'll probably never be. So it'd be real important that if I did get an opportunity to be free, chase my career, then I wouldn't end up working for somebody else. I can be my own boss and provide. That would be appreciated.
All right, so nobody's addressing the elephant in the room, which is your charges and what's in the narrative. So you're here for an unauthorized use of a vehicle. Let's talk about that. This case was in the middle of a jury trial. You decided to accept a plea. And according to the facts of this case, there was a medical student, nursing student, comes out, finds that her vehicle is gone. And I'm sure, and if I'm wrong, correct me if I'm wrong, I take no offense to that. I'm sure she had a family to support. That's why she's trying to better herself by going to nursing school. And she comes out and the car that either her parents got for her or she worked hard to obtain that vehicle is gone. And somebody else is riding around in her vehicle without her permission. And who do you think that person was?
I'm not sure.
It was you. You were riding around in her vehicle. What do you mean you're not sure? Who are you looking for? All right, so you were riding around in her vehicle. There was a video that was entered into evidence. The officers were having you remove your body from the vehicle. And what I remember on the video is the only person in that vehicle, when you were pulled over, was there somebody else in the vehicle that I missed?
No, Your Honor.
All right, so what do you mean you don't know who was in her vehicle? It was you. All right, is there anything else?
No, Your Honor.
All right, this is what the court is going to do. The court is finding you guilty. Court is sentencing you to 18 months in the state jail facility, give you credit for any time served. And I didn't see any mention of restitution, so I'm assuming there's no restitution. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
I didn't sign anything.
Is that your signature?
Yeah, what's that for?
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to the state. I'm sorry, you need to speak to an attorney. Do you understand?
That's understood.
I'm sorry, what?
Yes, that's understood. I can't get a weapon or any firearm.
Now, this last case centers on Mr. Thompson, who is facing serious theft charges with all evidence against him.
Court is calling 2024 CR 4934 and 2024 CR 5788, State versus Emmanuel Thompson. Can I have parties announced for the record for the state? Defense.
Eric Hernandez for defendant, Mr. Thompson.
And are you Mr. Thompson? Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Thompson, in each of the cause numbers, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each of the cause numbers, do you waive the reading of the indictment?
Who waived, Your Honor?
State, in each of the cause numbers, are you proceeding on the indictment as presented?
Yes.
In each of the cause numbers, did you review the documents entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 4934, you're charged with theft of property, 150,000 to 300,000 as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And the cause number ending in 5788, you're charged with theft, 2,500 to 30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights? And did you intend to give up those rights and enter into a plea in each of the cause numbers? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor, as to both.
Mr. Thompson, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it? According to the plea and the cause number ending in 5788, your punishment is to be assessed at 2 years in the state jail facility. And the cause number ending in 4934, your punishment is to be assessed at 5 years in the prison. In each cause number, there's an $800 fine, no applications. The cases will run concurrently, and the state will take in consideration 2024 CR 5789. Did you understand that to be the plea in each of the cause numbers? Defense, is that the plea in each cause number?
It is our agreement. Your Honor.
State, is that the plea? And each cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None.
Then in cause number 2024 CR 4934, how do you plead? Guilty, not guilty, or no contest?
Guilty.
In cause number 2024 CR 5788, how do you plead?
Guilty.
State any evidence.
No objection to either.
In each cause numbers, did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. So we're off the record. I'm just trying to get to the $150,000 to $300,000 in the one. So far, I see 24,000 in rings. Am I missing something? Sure.
I had the same problem, Your Honor. There is, I think the one that is in this county, in Bear County from Lee Michaels was valued at 197,000.
And I'm trying to find
It's
that.
kind of buried in the report because a lot
Okay.
of that stuff is from other stuff out of other counties.
Yes. So that's what I'm trying to find.
It's a little bit buried back in there, Megan. There's no dollar sign in front of it. There's no comma.
Oh, 197,000. Okay. All right. Thank you.
If you want to value.
All right. So no, but I will tell you, I haven't seen a ring in there for that amount. I'm gonna have to find out if there is. But okay. All right. In each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we've discussed it. Mr. Thompson believes this is the right decision, and he's just asking to receive credit for time served. I'm sorry, credit for any time that he's been in custody and other matters out of other counties from the time that this bench warrant was entered.
All right. In cause number 2024 CR 5788, the court is going to find you guilty, sentence you to 2 years in the state jail facility, give you credit for any time served. With regards to time he has when he was out of county, you'll need to make sure that the clerk is given those dates. This is run concurrent with 2024 CR 4934. Taking consideration 2024 CR 5789 and cause number 2024 CR 4934. As previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison. Give you credit for any time served. There's an $800 fine, time and money to run concurrent. This will run concurrent with 2024 CR 5788. Taking consideration 2024 CR 5789. Is there anything else with regards to sentencing?
No, Your Honor.
And each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, and let me get your dismissal. All right, thank you.